Wakeford to cross-examine Messrs. Agrizzi and Forster and for certain other matters to take place. The position is today that Messrs. Agrizzi and Forster will apply for a postponement for various reasons that will become apparent in due course. That at present is intended to be opposed by Mr. Wakeford. However, the differences between the parties and a thorough joint submission to you, Mr. Chair, is yet possible if the parties can be given an opportunity to speak to the investigator involved. Part of the dispute between Messrs. Agrizzi and Forster on the one hand and Mr. Wakeford on the other relates to factual matters of which there would be records in the Bosasa documentation. That Bosasa documentation is at present under the control of one or other curators who are in dispute as to who the curator lawfully is. That matter will be resolved by the Supreme Court of Appeal later in November when an appeal comes before it. The documentation relevant to these disputes was summoned as far back as June by the investigators, but that execution of that summons was resisted on the basis that the dispute had to be resolved before a curator properly appointed could release the documentation. And that is the explanation for the curators of Bosasa in liquidation not to comply with the summons. That documentation may be relevant to either party in promotion of either party's version of the facts. We don't know that yet until that documentation has been examined. So, Chair, what I have suggested to the parties is that they confirm the position with the investigators and then make an informed decision as to whether it wouldn't be preferable to wait for the outcome of that part of the investigation before proceeding. Otherwise, it may result in a multiplicity of hearings which might benefit no one, but I will make submissions on behalf of the legal team in due course, depending on the outcome of that discussion. So, in short, Chair, we're asking for a very short adjournment so that the parties may speak to the investigator to ascertain whether further information might be necessary for proper examination to take place.
Would 15 minutes be enough for that purpose?
Perhaps 20, Chair.
Maybe 20?
Yes, please.
Okay. I will grant that. What may have to be taken into account is that there may be no guarantee that the decision of the Supreme Court of Appeal would mean the end of that dispute, in the sense that, obviously I don't know the papers and so on, in the sense that there is still the constitutional court in case somebody is unhappy, and if they can find an issue that falls within the jurisdiction of that court.
Yes.
So in terms of possible delays.
No, I understand that, but in any event, the Commission would take steps then to compel production of the information.
Yeah, no, I'm mentioning this just so that everybody, as they confer with one another, they don't necessarily work on the basis that once there is a decision of the Supreme Court of Appeal, it necessarily will mean the end of the litigation. It might not.
Yes, that is true.
Yeah, that's the only point, yeah.
Yes.
Okay, all right. It's nearly 20 past 10. I will adjourn until 20 to 11.
Thank you, Chair.
Yes, we adjourn.
All rise.
My understanding is that when the time comes,
It's the usual story. First, he would be cross-examined by me, and thereafter wait for look of his evidence. It's not the other way around for some reason.
No.
announced or made and announced a few days ago. And I indicated that the cross-examination would take place today. I think I said today. It was on the understanding that all parties concerned were available. It may be that there was some misunderstanding in terms of the availability of all parties, but certainly it was on the understanding that the legal team understood the parties to be available and their lawyers, or at least that is what I understood. And I may have misunderstood something, but otherwise I wouldn't have issued a decision a few days ago and say cross-examination must start in 2 days or 3 days' time. I wouldn't have done that. I would have given everyone enough time. So it was only done on the understanding that there had been communication between the legal team and all the lawyers for the various parties, and my understanding was that they were available. If I had understood differently, I would have arranged that there should be another time. So I thought maybe I must just make that clear, that that's the context in which I said the cross-examination would take place today.
Thank you, Chair.
Thank you. Yes.
Thank you, Mr. Chairman. Chair, before communicating in precise terms
Yes.
my instruction, although
Yes.
Mr. Pretorius has indicated that there is consensus
Yes.
that we will concede the circumstances
Yeah.
that prevail. I'd just like to, I've been instructed and wish to place the following on record, Mr. Chairman. The first is a dissatisfaction on the part of our client, Mr. Wakeford, as to the commitment by Mr. Agrizzi and Mr. Forster to these proceedings and to being willing to be cross-examined and to hear his evidence. You were handed, when we saw you in chambers, the application for a postponement.
Yes.
Mr. Chairman, I'm not going to labour the issues, but must place on record that this affidavit that was placed before you ignores the facts in relation to the history of this matter. The facts in relation to the last few days are as you know them.
Yes.
But the affidavit does two things. It misrepresents the facts over the past number of months, in fact since the 26th of February when our client's application was brought. It strives to then tar our client with the results of today. This affidavit is willfully misleading of you, Mr. Chairman, and this Commission. It's there, but it serves no purpose in me taking it any further. Mr. Agrizzi knows the facts, and this will probably become material in the future in his cross-examination as to his credibility and his reliability. That speaks to the disparity of commitment and the frustration our client has experienced since the 29th of January, when he was implicated by Mr. Agrizzi before this Commission without compliance with the rules of this Commission. That wasn't necessarily directly Mr. Agrizzi's fault, but those were circumstances that prevailed for Mr. Wakeford. Mr. Chairman, Mr. Wakeford has declined all opportunities to respond to the media in good faith and in accordance with your own comments in this Commission. He has had to forego work opportunities, employment opportunities. You would have read in his application that his tenure employment tenure came to an end in April, and he has also had to experience a continual fleshing out of new facts and new information in the affidavits that have come before this Commission. The purpose of these submissions, Mr. Chairman, is in as much as he concedes the circumstances today, and consensually you may order a postponement of the proceedings. He asks that you order the parties to return as soon as at all possible, in accordance with the diaries of yourself and the various other stakeholders in this commission. Mr. Chairman, the discussions that endured in the adjournment between the investigating team and the legal team and the two other legal teams was to the effect that there is some outstanding information which will either suit one or other party or narrow the issues. In those circumstances, and in keeping with his commitment to cooperate, he isn't left with any opportunity but to accord with the advices given and the good faith dealings in particular by the legal team for the Commission and the investigating team. Those are the submissions, save if there's anything else that we can be of assistance with, Mr. Commissioner.
No, that's fine. I'm quite alive to the fact that Mr. Wakeford launched his application many months ago, and that there has been some delay in dealing with it. But I also do know that at a certain time when I thought it could be dealt with, I heard that he was intending to file some further affidavit, so we had to give him that opportunity. But the bottom line is that we want to try and, as far as possible, be fair to everybody. It wouldn't have been fair to everybody to proceed today in the circumstances which prevail. So that's fine. So I will postpone the matter at this stage without fixing a date, but with a clear understanding that everything that needs to be done should be done to make sure that we can fix a date as soon as possible. And what still remains in regard to the leave to cross-examine that has been granted is the question of how much time
Indeed,
will
sir.
be. Yes, so
I was going to ask after that shortly.
yes, in due course, that will have to be determined. I'm quite happy. If the legal team and your side, and I don't mind everybody, if they've got some submissions to make with regard to how much time should be set aside to make submissions, and obviously at some stage I will decide. As of today, I intended that I would determine that at the beginning of the cross-examination, if the cross-examination was going to proceed. But there is room for various submissions to be made, maybe written submissions ahead of the actual commencement of the hearing. So maybe I can leave that part to be agreed upon among all the legal teams in terms of who might want to submit, deliver written submissions, short written submissions on that, by when, and take from there. But should no submissions or no decision be made ahead of the first day of the cross-examination, I would then make the decision at the commencement of the hearing. But it might be preferable if it's done earlier than that, because then everyone has an idea of how much time is allocated, and therefore what are the important issues to focus on within the time allocated. But I think I can leave that to the various legal teams to agree upon, and and then that can be brought to my attention in due course.
Thank you, Mr. Chairman. That's
Yes.
a salient suggestion. We will take advantage of it and hopefully agree that
Yes.
and have that, the submissions referred to you if we
Yes.
can't agree on it, and you can
Yes.
decide
Yeah.
ahead of time.
Yes.
It would be very helpful if one,
Yes.
for us to know ahead of time
Yes.
what to expect.
Yeah.
Mr. Chairman, one last comment. Per instructions of our client is to thank you for the alacrity with which you dealt with his application once it was placed before you.
Thank you very much.
Thank you, Mr.
Thank you.
Chair.
I don't know if counsel for Mr. Agrizzi and Mr. Foster wishes to say anything.
If it pleases the Honourable Chairperson, there are just certain matters that I just have been instructed to just record
Yes.
at your discretion. I have taken cognizance of Advocate Willis's comments regarding the affidavit that was submitted, and in order to comply with the substantive application requirement before this commission, I will pass those comments on to Mr. Witts, and they can be dealt with by him accordingly.
Yes.
Just as far as Mr. Agrizzi is concerned, and I have appreciation for the fact that Mr. Wakeford, is to a certain extent has placed before your honourable self the fact that he is severely prejudiced. I do believe that that ought to be balanced by the fact that Mr. Agrizzi has not sought an indulgence of this kind before this commission at any point in time since he has been part of these proceedings. He has been present at every single instance that he has been required to do so. The nature of these proceedings is that prejudice will be suffered by implication. These proceedings are laying a scalpel into the bare essentials that undermine our democracy. If that was not true, the President would not have ordered it, and your honourable self would not have been presiding in this matter for the time that you have been. My bottom line is that the rules of natural justice in respect of providing Mr. Agrizzi and every party here an opportunity to deal with these matters properly and appropriately so that everything can be laid bare and there is a complete understanding of the nature of whatever went on is important. As far as the times, just for the for the information of the various parties, I have been advised that times have been suggested and they are similarly contained. Periods of either the 18th, the week of the 18th to the 21st of November, or the 2nd to the 6th of December. Those might be dates that can be kept in mind. My further instruction is that, depending, of course, on your honourable, the Honourable Commissioner's discretion and direction, that Mr. Agrizzi's team would need at least 3 days in order to cross-examine Mr. Wakeford. And as for the remainder, I believe that that has been dealt with by either Mr. Willis or the other members of this commission.
Yeah, okay, all right.
Thank you, sir.
You must those advising Mr. Agrizzi must just remember to have a look at the rules and see whether there are any procedural steps that must be
I will
taken care
advise
of
them
first.
accordingly.
Yes.
Thank you, sir.
I must just say, for what it's worth, as different sides contemplate making submissions with regard to the time that can be allowed, that I should consider allowing for cross-examination. They should take into account that I'm inclined not to allow too much time, but at the same time, I don't want to be unfair and therefore to parties and allow too little time. So,
Honourable Chairman, I think
you will bear that in mind.
I think we all agree that we serve at your discretion and at your
Yes.
pleasure in this instance, and we take your
Yes.
direction accordingly.
Yes, I think the first time when I determined allocated time for cross-examination was with regard to, I think, the cross-examination of Mr. Jonas. I don't know whether also Ms. Mentor. I think at that time, I may have granted an hour or two or thereabout. Yesterday, not yesterday. Yeah, I think in the past it was about an hour or two, but obviously it depends on the issues and how fast they are. But I just want everybody to take that into account.
I take that into consideration. Thank you, sir.
Yes, thank you very much. Mr. Pretorius.
Thank you, Chair. Just 3 points. Firstly, the legal team appreciates the cooperation of the parties. It is obviously best for the investigative work of the Commission that evidence and cross-examination takes place on as thorough an investigation into the underlying facts as possible. The second point is that to place the history of this matter in its proper context, it was concluded by the filing of a reply on behalf of Mr. Wakeford of some 290 pages on the 1st of October, in other words, very recently. So in assessing the delay, that must be taken into account. And thirdly, it's important to put one matter straight and on the record, Chair. It has been said today and in public and in correspondence many times that Mr. Agrizzi implicated witnesses without compliance with the rules. That is not correct. There was if regard is had to the record, which is available for all to read, the evidence of Mr. Agrizzi was given after a comprehensive and proper application in terms of the rules that he do so without the issue of 3-3 notices in particular circumstances that were placed in evidence before you, Chair.
Yes.
Thank you, Chair.
So in other words, you just remind everybody that to the extent that there might not have been any Rule 3-3 notices that were issued, it was under circumstances that the legal team submitted justified doing that, and that was placed before the Commission.
Yes. And you permitted it, Chair, in terms of the rules.
Yes.
Thank you, Chair.
Yes, thank you. I'm going to postpone the cross-examination of Mr. Agrizzi and Mr. Foster by counsel for Mr. Wakeford. I'm not going to fix any date because that must still be worked out. But attempts will be made to fix a date as soon as possible. And I've no doubt that the investigation that must be carried out in order to facilitate that cross-examination is going to be done as soon as possible. So the cross-examination of Mr. Agrizzi and Mr. Foster is postponed sine die, and another date will be determined in due course. That puts us at the end of the proceedings of today. We, Mr. Pretorius, are not having any witnesses tomorrow and Friday. Is that confirmed?
Friday is still relatively uncertain. I say relatively uncertain. The witness for that day will probably not appear, but there is a chance that it can still be arranged and notification can be given to today.
So somebody must just let me know, but certainly not tomorrow. There's no witness tomorrow.
Correct.
And with regard to there will be no hearing on Monday and Tuesday next week as well.
Correct, Chair.
There will be a hearing on Wednesday involving a witness from the Free State government in relation to Estina. So the public will be advised about Friday, either sometime today or tomorrow.
Thank you, Chair.
We adjourn.